I pray for leave to file one urgent matter, my lord. My lord, vacating notice issued, my lord.
Tenant.
No, my lord, I am the co-owner of the land, my lord.
Yes.
Without issuing any hearing notice, without inspection.
Demolition order.
Yes, my lord.
You have a sanction plan.
Yes, my lord, I have sanction plan, my lord. But the municipal authority, my lord, suddenly issued demolition notice. Before that, my lord, no hearing has been given, no inspection has been held by the municipal authority. The petitioner came to know, firstly, my lord, from issuing the vacating notice, my lord. No opportunity of your lordship knows better, my lord, without giving any opportunity of hearing, my lord.
All right. Appellate side.
Appellate side, my lord.
Calculate.
Grateful, your lordship.
My lord, I am
Tomorrow.
I'll give you the.
Or you have not, you have sent notice or not? Given notice?
My lord, Mr. Banerjee is appearing on behalf of the minister.
You should give a notice and then mention it.
My lord, if your lordship allowed me, my lord, then I will.
I'll give notice to him.
Lord, may I mention, my lord,
Yes.
item number 48 of the original side list, my lord. I'm only praying this, my lord, in case it is not taken up, kindly take it up, my lord, anytime. It's a very short matter. Corporation has inspected.
Say any urgency.
Well, urgency, I'll tell you, lordship, in the middle, it's a very old building. In the middle of the courtyard, corporation has inspected and found entire up to the roof, a structure has come up. And which is, there is no sanction plan. There is an inspection report. There is an order of court.
But what is the urgency?
But I was only saying, well, it will not take any, because there is already an order of court. Well, we are not getting a chance. Well, that is the.
We'll see. We'll see.
But in case, I'm only saying I'm not disturbing your lordship's schedule.
See, in case today is the last day. So if it doesn't reach till 48, which is unlikely today, because I have a division bench also after lunch.
That is why I'm saying, well, at 2 o'clock, 4 o'clock, anytime.
Not possible. After vacation.
Very well.
Have it after.
Otherwise, well,
After vacation.
very well.
Well, may I be permitted to mention item number 287?
Well, let it be slightly upgraded after the vacation.
And that I can.
Kindly. The item number 48.
Just make a note of it. Item 40.
What is it?
My lord, last occasion it was mentioned before your lordship, my lord, regarding my lord,
Mr. Mrityunjay.
my lord, regarding my lord, disbursement of fund, my lord, because my lord, I have done the work for the last 2 years, my lord, no fund.
All disbursement of fund after the
My lord, kindly upgrade this matter. Then it can be, my lord, taken up, my lord, after vacation.
after
My lord, kindly upgrade
after,
it, my lord.
After vacation, we'll see. After vacation.
My lord, for a
After vacation.
My lord, I am praying, my lord. My lord, item number 100 of the today's list, appellate side list. My lord, kindly consider the situation, my lord. Once, my lord.
What situation?
My lord, kindly see, my lord.
What is there? Tell me.
My lord, this unauthorized construction has been constructed on the staircase towards roof,
Good.
my lord. And for this, my lord,
Unauthorized construction only putting a
iron grill, my lord.
Iron
This
grill.
is like cage, my lord. My lord, petitioner, my lord, the whole difficulty is, my lord, petitioner is unable to reach rooftop, my lord. Where is the water tank situated, my lord? For more than 1 year, my lord, that has not been maintained, my lord. And the main difficulty is that, my lord, minor members of the family are suffering, my lord, for waterborne diseases, my lord. This has been constructed by the respondent.
All right.
My lord,
We'll see.
considering urgency,
Due
my lord.
course of time. Nothing, no urgency.
My lord, I am praying leave, my lord, to move this matter in the vacation bench, my lord. The urgency is, my lord, without violating the interim order of the learned code below. The respondent number is continuing the construction without any sanction plan, which is unauthorized and illegal, my lord.
Nothing doing. Sorry. Mentioned it before the vacation bench. Yes.
Your Lordship, we have filed this application.
Yes.
So there was an order of your Lordship's order on 17th July
Yes, Mr.
for taking hearing of our representations. The hearings have been concluded in August 24th, 25th.
Yes.
Till date, no order is being passed, and as a result, what is happening here, unauthorized construction is going on. I understand your Lordship, we have filed it yesterday, and it's a last day. I only was beseeching if this could be taken up, because that's a matter of them to be told to give us the order. It could be taken
Mr.
up in
Sinha,
hearing during the vacation. If it's the leave to give it, only move it to the vacation. I only want that.
vacation bench.
May please, my lord.
That's what.
Not before you ask before the vacation
Your
bench.
lordship,
I know the first day it will not come, it will come on the next day. That's not a problem.
very well.
May it please, my lords. My lord, I am stretching for my luck. I mentioned this matter on 4th.
Yes.
My lord was pleased to reject it. The only issue is the unauthorized construction is changing hands. In case any untoward situation,
We are not concerned
No,
with the
all I'm asking for is
construction changing hands.
no. All I'm seeking a direction that leave be granted. In case any problem, I can move before the vacation bench.
You always have that liberty.
No. I do, but then
mentioned
it is
before the-
already filed in August. So now that it is running in the monthly list, item number 200 and
Sir, you
2,800.
can always mention before the vacation bench. They will take it up. You don't have to seek my leave for that. It's only for the first day you might have
My lord,
have to seek leave, but nothing more.
if that
no,
be
sir,
considered
nothing.
only because it is a long stretch of holidays.
Mention before the vacation bench.
Lord, I'm seeking a leave, my lord.
Much obliged.
This matter, my lord, urgently, and my lord, moved in the vacation bench. My lord, the urgency is that, my lord, the death certificate of the husband of the petitioner is, my lord, not being issued, my lord, by the municipality.
When did you apply for the death
My lord,
certificate?
applied, my lord, he died in, my lord, April this year. After that, my lord, regular, my lord, representations and, my lord, RTI applications, my lord, have been made, my lord, nothing. Now, my lord, the urgency is that, my lord, the school authority of the child, my lord, they are seeking, my lord, the death certificate to record it. Otherwise, grateful, my lord.
Vacation bench. The first vacation bench is my lord. Yes, call out the matters. Judgments. This is the first one, na? देख लिया ना? Just check the writ number. यही है ना? In view of the clear stand taken by the UDMA department, this court holds that there is no requirement for obtaining any further approval from the said department in respect of the leave period of the petitioner. Accordingly, DPPG is directed to issue the pension payment order in favor of the petitioner within a period of 2 weeks from the date of communication of this order. Upon issuance of the PPO, the respondent municipality shall release the arrears of pension, gratuity, and all other retirement dues of the petitioner within a period of 4 weeks. With the aforesaid direction, the presented petition stands disposed of.
Much obliged, Lord. Grateful, my lord.
अच्छे थे ना 25th. Since the Department of UDMA is maintaining that maintaining the stand that the land in question already stands acquired in its favor, this court finds no illegality or infirmity in the stance of the respondent corporation that unless a no objection certificate is issued by UDMA, mutation cannot be effected in favor of the petitioner. Accordingly, the presented petition being devoid of merit is dismissed. Interim order dated so and so is extended from time to time, he is hereby vacated. It is, however, made clear that the petitioner is aggrieved by the stand taken by the UDMA. He shall be at liberty to challenge the same in accordance with law. Mukherjee is not here.
Mr. Mukherjee is on his way, my lord.
He's on
I
his
am
way.
led by Mr. Mukherjee.
In view of the detailed discussion herein above, this court is of considered view that the petitioner, being the auction purchaser of the premises in question, is liable to pay the outstanding property tax dues. The official liquidator, though sale notice and the EOI has made it very evident and clear that all the bidders are supposed to make their respective bids based on their own investigation and due diligence. As discussed herein above, the Honorable Supreme Court in Union of India versus KC Ninal, where when assets are sold on as is where is basis, the purchaser acquires them with full knowledge that they are being sold without any warranties, representation, or indemnities, and the purchaser unknown bears the responsibility of verifying the condition, liability, and encumbrance attached to the asset. Further, Section 232 of the KMC Act makes the property tax dues as first charge on the property and hence makes it an encumbrance attached to the property. Hence, the petitioner is liable to make the payment towards outstanding property dues for the pre-liquidation period. In view of the detailed analysis and discussion herein, this court finds no illegality, arbitrariness, or infirmity in the letter dated 18/11/24 issued by the respondent corporation. The refusal to grant mutation of the 4 leasehold units being A 201, 202, 301, and 302 together with 6-car parking situated and so in the name of the petitioner on account of outstanding tax and other statutory dues is fully justified on account of outstanding property tax and statutory dues is fully justified in accordance with law. The respondent corporation acted squarely within its statutory mandate under section 183(5) and 232 of the KMC Act and in consonance with the principles of statutory charge and municipal enforcement. Accordingly, the writ petition is dismissed.
Grateful,
Great.
Lord.
My lord, may I pay for a stay of operation, my lord, of this
Stay?
order?
No.
The
Stay.
upcoming
There is
vacation,
no
my lord,
question of any stay.
No stay.
my lord, upcoming vacation is this,
Might
my
be
lord,
so.
No, sir.
only for
Mentioned
3
before the vacation. No stay. Mr. Mukherjee, it was difficult.
There is one difficulty.
I'm saying this will go
No, I'm ready for that.
my lord,
I'm ready
very,
for,
very, very
I'm
interesting.
ready for that.
Very interesting.
Yes, ma'am.
my lord, may I repeat my prayer, my lord, for stay of operation?
No, sir.
Since the upcoming vacation is there, my lord.
Mentioned before the vacation.
I'm for the petitioner.
I appear for the respondents, my lord. Respondent number 8.
Just a minute.
I am for the Kolkata Municipal Court.
Just a minute, sir.
My lord, kindly looks into the order dated 31st of July.
Just a minute, sir.
Kindly consider, my lord, this matter, my lord, seriously corporate.
Mr. Chakravarti, just a minute.
My lord. Yes, July. 31 July.
तो अपलोड करा. Yes.
My lord, in this matter, Lordship kindly see on the last occasion, Lordship was kind enough to, my lord, extend time to file affidavit to Kolkata Municipal Corporation 31st July. Lord, no affidavit so far filed.
This
And
is the
my-
first time. This is the first time.
8 weeks time was awarded. থামুন না, আপনি তো
না,
বলছেন
আপনার তো আমাকে তো দিতে হবে। আপনি বলে যাচ্ছেন কেন? আমাকে তো দিতে হবে। এরকম ভাবে বলতে হবে।
সারাক্ষণই তো বলে যান। My lord, kindly see, my lord, kindly see the
অদ্ভুত
old person, my lord, at the fag end of his life, his neighbor is doing construction in collusion with the Kolkata Municipal Corporation, and the, my lord, the construction is going on merrily, and my lord, the KMC people are, my lord, sitting tight, and my lord, this is their conduct. In one occasion on 20th November 2024, Honorable Court was kind enough, the prima facie view was, my lord, should modify the structure by setting it back at least 4 feet from the common boundary wall. There was a prima facie view, and KMC did nothing, allowing them to do construction. And here, my lord, they are taking time, no evidence, nothing of this sort. And my lord, I am suffering, my lord, ancient right to light, right to air, everything, my lord. And my lord, I can show, my lord, the photograph. Lordship will find from the photograph, my lord, there is, my lord, there's no gap of rather 1 feet gap is not available in the structure. Lord, kindly see, may I hand it over, my lord?
Last occasion I have
This
filed a report, my lord.
This is, my lord, affidavit in reply. And my lord, there was a commissioner appointed by the Honorable Court. Commissioner is of the opinion the structure is doing without, my lord, adhering to the rules and regulation of the Kolkata Municipal Corporation. And that being the situation, here, my lord, no affidavit so far.
Only one first affidavit of direction was given in the last occasion, my lord. I am praying with your lordships. 1 week time may be given. I will file my affidavit. In the meantime, my lord, we have already made an inspection. After inspection, we have found that the construction was going on in accordance with the plan, and that report was already filed before your lordship. In any manner, my lord, I will. In any manner, my lord, I will come with an affidavit if your lordship give some time, because already the construction has completed and it is not so urgent, my lord.
My lord, if their report is sacrosanct, in that case, no further report is required or no reply, no affidavit. Kindly allow me, my lord, to place my case.
They want to file their affidavit. Direction is there. So
Yes, my lord, direction is there.
let them file their affidavit.
That is on, my lord, 31st July.
Yes.
2025, 8 weeks time was given, my lord.
4 weeks time was given.
Yeah, my lord, the total 8 weeks, 4 weeks to them, my lord, and reply on all these things and matter to appear after 8 weeks. And 8 weeks have been elapsed.
You file your affidavit, Mr. Manager.
And last time I will file my affidavit by 1 week after division.
Learned counsel for the respondent, Calcutta Municipal Corporation, seeks and is granted further time of 1 week after vacation to file his affidavit in opposition. Full stop. This is the last opportunity granted to the learned counsel for the respondent corporation to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter.
My lord, 1 week is enough. 1 week is enough.
1 week thereafter. List on. Give a date. 13th. 13th November.
At the top, my lord, since he is, my lord, 86-year old, my lord.
18th November.
Yes, lift up.
13th November. Sorry, 13th November.
Lift up.
Grateful, man.
13 November. 13 November.
Ready for.
May please your lordship, Lord.
Yeah.
This is, my lord, in connection with, my lord, one of the iconic but old buildings, my lord, Stephen House. Now, my lord, here there are 5 premises numbers: A, B, C, D, and E of 56. A, B, C, D, and E. Now, all these 5 pertain, my lord, to the building in question. Up to absolutely current July 2025, we have no outstanding certificates showing that the entire taxes have been paid.
Right.
Now, Lord, we have annexed the certificates. For instance, if your lordship kindly looks at one at page 20, annexure P1, there is, my lord, in respect of 56A, as late as on 10th of July 2025, an NOC regarding no outstanding amount being due. My lord has seen, my lord, page 20, 20.
Page 20. Yes.
Lord, this NOC shows that it is a due on the basis of the last annual valuation of 1,62,46,780 with effect from first quarter 2017-2018. On that rate, I have paid up to date. Therefore, on the 10th of July 2025, there is, my lord, the NOC granted. Similarly, in respect of my lord, premises numbers 56B, C.
This one is 56A, right?
Please come, my lord, to the next one. It's 56A again. Here, the NOC is based on the annual valuation of.
Next one is 56B.
B. Once again, NOC granted. That means I have paid up to date. Next one is 56C.
Yes.
Once again, NOC granted. Then, my lord, it's 56D. Then, my lord, 56E at page 24. All these 5 premises pertain to the same land and building. It's inseparable in parts because, my lord, it was, my lord.
They have still not raised the demand, right?
No, they have not. This is an NOC.
Yes.
Now, what they are doing is something which we are in a quandary about. We are not, we will be happy to go back to the municipal commissioner and argue our points there. But the difficulty is this. My lord, see, the NOCs have been granted in respect of fourth quarter 2016-2017 in respect of the premises numbers B, C, D, and E. And in respect of premises number A, it has been granted up to the annual value of first quarter 2017-2018. Please come to page 20.
Yes.
First quarter 2017-2018, kindly see the line in the middle. This NOC is based on the annual value of 1,62,46,780 with effect from first quarter 2017. That means 1st of April 2017, financial year 2017-2018. The others, each of them, my lord, is on the basis of fourth quarter 2016-2017. That's the previous quarter prior to the UAA. The UAA system has come into vogue from 1st of April 2017. Now, so I have my NOCs cleared in respect of the ARV valuation arena for all the 5 premises numbers. In respect of the first major premises number, because my lord will see that this is the premises number against which the bulk assessment has been made.
So that is also pre-AV only.
This is first quarter with effect from first quarter 2017, which means this is UAA.
First quarter after April, it's UA, right?
First quarter, April.
So first quarter is
April.
After April onwards.
Yes, so April onwards. So this is for.
This is prior to that.
No, this NOC is based on the annual value.
Annual value
Of rupees 1,62,46,780 with effect from first quarter 2017. This means the annual value that was fixed, WEF first quarter 2017, which is the UAA, the first UAA valuation. The first premises has the first UAA valuation and the other 4 premises numbers have the last ARV valuation. On the basis of that, on 10th of July 2025, I have received NOCs. That means I have been making payment of all the taxes in respect of all the 5 accounts, though the same pertain to the same building. Now, my lord, what has happened is this. The corporation has issued a letter of 17th May 2025. Now, this is what they say in their letter. Notices under section 185, my lord, that's at page 25. Notices issued under section 185 of the KMC Act in respect of the 5 premises. With reference to the caption subject matter, the undersigned has been directed to inform you as follows. Notices issued earlier under section 185 in respect of premises 56A, vide notice number such and such against proposed annual value of 4551340 with effect from first quarter 2011. Notice number such and such against proposed annual value of 4976910 with effect from fourth quarter 2013. Notice number such and such against the proposed annual value of 5466320 with effect from fourth quarter 2016 have been withdrawn as well as rescinded with immediate effect. So these 3 notices were apparently issued. Now they have been withdrawn. Notice issued earlier under 185 of the KMC Act in respect of 56B, vide notice number such and such against proposed AV of 3384000 with effect from first quarter 2014-15, 2014 has been withdrawn and rescinded with immediate effect. So they have again issued retrospective notices and they have rescinded them. Now, notices under 185 for inviting objections under 186, if any, apropos annual valuations both under ARV and UAA proposed by the corporation under section 180 subsection 2 in respect of the caption premises numbers are enclosed herewith for taking necessary action in accordance with the provisions laid down in the Act. If no objection is filed in response to the notices against the proposed annual valuations, Municipal Commissioner or his representative will proceed to consider such valuations. Now, my lord, this has been given, and along with that, my lord, a series of notices has been given. All of them during the ARV period violate Sahujan. All of them. Sahujan's ratio. See, please see, my lord, page 26. They are proposing for premises number 56A, the number, my lord, will find in the longish rectangle in the middle of the page. 56A Hemonto Basu Sarani is the premises number. Annual rateable value proposed is 4551340. WEF first quarter 2011. That means in 2025, the date of the notice is 14th of May 2025. My lord will find bottom left. So in 2025, they are serving up a notice to reopen the ARV for first quarter 2011. This is in the teeth of the judgment of the division bench in Sahujan, my lord. I placed in on earlier occasions also, my lord. In other matters, my lord, it has been placed. I'll place that later. My lord, kindly, my lord, come to the next one. Now again, in respect of premises number 56A, another retrospective ARV valuation is being made, page 27, with effect from fourth quarter 2013-2014. Again, more than 3 years from the date of the revising order, because the revising notice is 14th May 2025, bottom left. And the valuation proposed is fourth quarter 2013. So there's a clear gap of 12 years. Now, my lord, in the next one also, fourth quarter 2016, there is again another notice regarding 56A. Here also the gap is, my lord, 14th May 2025 to fourth quarter 2016, roughly a 9-year gap. If your lordship comes to the next one, that's the UAA. UAA is first quarter 2017. They are redoing an assessment in a proposed assessment in respect of, my lord, the annual valuation with pertaining to first quarter 2017. This is also being done on 14th May 2025, more than 6 years from the date of the revising order, which they can't do under the UAA. So all these notices up to page 29 I have shown. Even page 30, this is also more than 6 years from the date of the revising order. If you go back, allot 14th May, page 30, first quarter 2018. Then the next one is
file your response. These are notices.
These are notices. These notices which are time barred are hit by the law straight away. So I'm challenging their jurisdiction. What I can do is, Lord, if I go to the hearing officer, he will assess me on merits. Hearing officer does not have any jurisdiction to go enter into the proposals.
This
Lord,
is jumping the gun.
My lord, may I just do this? May I file my response regarding the maintainability of the proposals before the commissioner? I have already filed my responses.
Do whatever you have to do.
Lord, I'll just say why. These assessments which are being made are in the teeth of settled judgments of this honorable court, Lord, regarding
That's all right. Every department has a right to proceed.
But would your lordship kindly see this judgment?
Mr. Banerjee, file your objections before the municipality.
Yes, I'll do that. But if they let the municipal commissioner consider these objections relating to maintenance.
Whatever he will do, he will do. I'm not going to preempt him. I'm not going to advise him. I'm not going to guide him. Law, he will also follow law. He's an officer.
Yes,
of the corporation. I'm sure he's aware of what he needs to do.
Then, my lord, only may I just have this? My lord, these are the assessments that have been made up to now. All the notices, my lord, we've annexed.
These are only notices.
Yes, these are notices. Yes, at the show cause stage, my lord will not be pleased to interfere in jurisdiction, in jurisdiction, unless there's a manifest excess of jurisdiction.
Correct.
Here I can show, my lord, the excess of jurisdiction qua Sahujan.
Sorry, Mr.
Sahujan is only 3
Today,
years.
I will not pass any order in any way which will preempt them to consider your objection. All your objections are left open. make it before the
But
hearing officer, Sahu Jain and everything. At this stage, I'm not going to do anything.
my lord, then only may I pray for this. They have invited me to a hearing before the municipal commissioner or his
Go there.
representative.
Go
May I go before the municipal commissioner? He is the statutory authority under the act.
I am not going to, if he is the statutory authority and if he has delegated his power, can I stop him from delegating his power?
No,
He is entitled to.
my lord,
The assessor and collector generally does all the hearings.
all the hearings. But
And he will continue doing the hearings
as a delegate of the municipal
as a
commissioner,
delegate of the commissioner. And the law is very clear to that extent.
then my lord, may I only my lord say this? As far as my objections relating to maintainability are concerned, they will also be considered. All objections.
See, you have a right. If they don't consider, come back to me. But
I
at
will-
this stage, I will not do anything.
I will first go to them and my lord, then my lord kindly permit me, my lord, to do this. They have made a series of assessments which are all retrospective. I have put in 2 objections. One challenging maintainability, the other asking for information. I will file, my lord, my comprehensive objection. Please permit me to file a comprehensive objection.
You always have the liberty. Who's stopping you from filing any
There's a
objection?
liberty given in the notices. If your lordship kindly extends the time for a brief file so that I can file it, and then, my lord, let them hear it out and dispose it of. There are 2 objections on record. May I show your lordship, my lord, the objections? I just wanted to file a comprehensive one where I take all the points.
See, whatever you want to do, you do it in accordance with law.
Yes, yes. Your
So-
lordship kindly grants me the liberty to do it. That liberty will not create any added right in my favor. It's just that I put all the points which I have canvassed here, my lord, in a comprehensive written objection, so that it can be dealt with by whichever authority, my lord, the corporation thinks fit. In the event they don't act in accordance with the law decided by this honorable court, I will always be at liberty, my lord, to take appropriate steps.
Okay, take down. The petitioner has
Lord,
filed
I'm
the-
submitting to that. I do not know, my lord, whether the date
You're
of,
appearing, Mr. Ghosh.
date of hearing was fixed, my lord. Whether earlier to that, my lord, my Lord has raised an objection or the valuation has been, my lord, finalized. I do not know, my lord.
Then
Because
let
the
that
matter-
information be taken. If it is
That
finalized,
matter was
that's
in the quite, my lord, the list, my lord, that information has not come. Of course, he can go to the authorities.
No.
But in the meantime, if it is, well, the final, my Lord could, my lord, enlarge into a lawsuit, whether the valuation order will be fixed or not.
my lord, valuations have not been
If
fixed. they are
valuation
pending.
order would have fixed, he would have challenged that.
Yes.
He could challenge. The valuation could be challenged. There is no
Absolutely.
difficulty.
Valuation order has not yet been fixed, but what is happening is, my lord, in their assessment register, even prior to the issuance of the notices, please come to page 56, they are showing all these valuations as having finalized. This is even prior to, my lord, the notice, the second branch of notices coming. Would your lordship kindly see, my lord, page 56? Please see, my lord, page 56. Now, my lord, kindly see, my lord, UAA is mentioned, my lord, in that slab. From 15th of May 2025, there are 1, 2, 3, 4, 5, 6 valuations which they are saying have already taken effect. But the notice which I have received is on the 14th of May 2025, telling me to appear on 20th of June, on which day they gave me an accommodation because I will be moving court. Would your lordship, my lord, please compare it with any of the notices. The notice, let us say, my lord, at page 28 or 26 for that matter. My lord,
We
page
don't,
20
we don't really know
Yes.
what,
So this, what is being reflected here is wrong. Ex facie wrong, because at page 26, the notice is given on 14th of May 2025, and that's for the purpose of a hearing scheduled on 20th of June.
Let them judge, my lord, whatever the objection they put, my lord, before the competent authority.
No,
And
but
all issues to be decided by them.
Yes, but for that I need to know whether it's been finalized. Would Mr. Ghosh, my lord, please take instructions? Maybe come back at 1.
Let them, my lord, on that point, my lord, also, my lord, he is saying that it is earlier to that, raised into a point that will be decided by the competent person.
If valuation has already been
but
finalized,
has the valuation been finalized?
That I do not know, my lord. My
Give
land affairs, but I am just, that is why he
Mr.
could, my
Ghosh,
lord,
if you can come back with
come
the
back with
instruction,
instruction at 1, we can finish it off.
then we can dispose
then,
it.
your lordship, my lord, takes it up after the vacation immediately. I can, my lord, ascertain whether the valuation has been fixed because the notice had already been issued. Earlier to that, my land affairs now saying that the valuation has been determined.
No, it's not been determined. It's being shown to have been determined in the assessment register. Your notices show that the hearing is in June 2025. The register shows in 15th May. It has been done.
At the request of the parties, let this matter be listed after vacation.
Well, Your Lordship, my lord,
In the event they have not finalized the valuation, otherwise, my lord,
I'm not saying anything.
Well, if they have finalized it already, my lord, need not say anything, my lord. If they have not finalized,
Then I'll dispose it off.
yes, yes. So therefore, my lord, kindly, my lord, let them not finalize
in
it.
that way, Your Lordship.
I can dispose it off right now.
Yes, but in that way, Your Lordship, do it, my
The
lord.
coach just tell.
See, you are aware, Mr. Banerjee.
No, I'm not aware. Here I'm in a quandary.
No. Your client would be aware if he has attended the
He
hearing
has
or not.
attended the hearing. He was given an accommodation.
Accommodation.
Date is fixed in the notice itself.
Yes.
But the assessment register shows that on 15th of May, the valuations have been done. Please have a look. Please have a look. Please have a look at page 56.
That is not really.
So they are showing.
You can't really say that it's an assessment.
My lord, the assessment book is a statutory book. They are bound by it. Please see, my lord, page 56. Just once, my lord, for my satisfaction. Page 56 only, my lord. That assessment book extract which we have taken from the portal. Would your lordship kindly see, my lord? UAA, if your lordship kindly sees in that big table, my lord, here at the bottom, UAA valuations start from the 5th row. From the 5th row till the 10th row downwards, all of them, they say, has been heard on 15th of May 2025. Has your lordship seen, my lord? Date of alteration of AV is 15th of May 2025. With effect from 1st April 2019, etc. But all the hearing dates they are showing as 15th of May 2025. On the contrary, if your lordship looks at the notice, any notice, my lord, for instance, at page 28, my lord will find that a date for hearing has been fixed on 20th of June. Please come to page 28, my lord. This is where we are in a quandary. We don't know what's happening. Our objections are on record. Our preliminary objections are on record.
So then let it. I'll simply re-notify it. I'll simply re-notify after vacation. I'm not going to do anything.
Re-notify. Tell them to serve fresh notices.
Absolutely. Not re-notify in that sense. I'll say I'll just, at the request of the parties, let this matter be listed in November.
After the vacation.
After that.
My lord, only one prayer, my lord, only very humble, one prayer. If they have not finalized.
If Mr. Ghosh can come back with the instruction, we can dispose it off.
1 o'clock, my lord, it's just one telephone call away.
Just find out, Mr. Ghosh, we can dispose it off.
Dispose it off, my lord.
We'll keep it at 1 o'clock.
Yes, at 1
Well,
o'clock.
I'm just requesting my lieutenant engineer to call
All right. At 1.
If it is not, then Your Lordship, of course, my lord.
Then after vacation.
Yes. Oblige, your lordship.
I'm for the
Job.
Yes.
Well, the petitioner before your lordship is the owner of half of the portion of 162 Bipin Bihari Ganguly Street, Kolkata.
Yes.
And half of the other portion of the same property, 162.
I have a preliminary objection, madam. Two of the respondents.
Who are you?
I for the respondent number 7, private respondent.
Madam, I for the respondent number 8.
Preliminary objection, madam. Two of the respondents are outside jurisdiction of this original site jurisdiction of this honorable court, madam. Since they are outside, madam.
Outside? Which?
Yes, madam. Kindly have a look at the cost type.
Lord, the authorities are all within the jurisdiction. Lord, the
That's
property
fine.
situates within jurisdiction.
Respondent number 6
Property-
is outside. Respondent number 6 is outside, madam. And all the respondents ought to be within the original site jurisdiction of this honorable court in order of this honorable court to exercise jurisdiction. Respondent number 6 is outside. And so is respondent number 8.
No, respondent number 8 is not outside jurisdiction. No.
Madam, may I kindly have a look
No.
at the cost title itself.
It's Rajarhat.
Rajarhat.
Outside. Outside the original jurisdiction of this.
The
honorable court.
property is within the
But it's
jurisdiction.
not the
And
determining
she has been
factor,
thrown out by this,
This
by
is-
the respondent number 7.
This is not the determining
So-
factor, madam. All the respondents have
The
to be
property
within
is within the
property, of course,
jurisdiction.
has to be within jurisdiction also.
What is the original site rule says?
Lord,
Property
the
within the
property is within the jurisdiction. The all
That is for the
authorities
suit.
against whom the Article 226 is invoked, they are all within jurisdiction.
Show me the appellate site. The original site rules. Does all the respondents? Yes. What does it say? All the respondents have to be.
Well, if the property is within jurisdiction, my lord, and the corporation authorities are within jurisdiction, where the records are lying, the records are being challenged, the writ of certiorari is being prayed for bringing the records before this honorable court to certify.
Mr. Banerjee, Banerjee, what does the original side rule says as far as jurisdiction is concerned? If two of the respondents are outside the original side jurisdiction, the writ is maintainable?
Ordinarily, my lord, the rule says the cause of action has to be entirely within the jurisdiction of the original side, and all defendants in the suit have to be within the original side for the matter to be on the original side. If any of the defendants is outside jurisdiction,
that's for the suit.
Same thing follows in writ. Same thing follows in writ. Kindly substitute plaintiffs by petitioners, defendants by respondents. Same thing follows here in writs, because in writs, the writ rules say that apart from the specific writ rules which have been framed by this honorable court, other rules relating to procedure will mutatis mutandis apply according to the original side rules or the appellate side rules, as the case may be. So here, technically, if even one defendant is outside the jurisdiction, then it is outside the original side. It should be converted into an appellate side petition and sent in the appellate side. Having said that, there is a single bench judgment which had dismissed writ petitions on that ground. Justice Boshak, when his lordship was taking it up singly. From there, a division bench, my lord, was approached, Justice Pranab Kumar Chattopadhyay's division bench, and other division benches were also shown where it has been held that this is broadly a rule of procedure for the purpose of demarcation of the two sides. This doesn't ipso facto denude the honorable judge sitting in the original side of jurisdiction if otherwise the cause of action has arisen within his jurisdiction. That means if the cause of action has arisen, let us say in 5 SN Banerjee Road, which is the main office of the corporation where all the assessors sit, but one of the private respondents stays in Tollygunj, which is outside, that ipso facto may not denude the honorable judge taking up original side matters of jurisdiction to take it up in the original side. There are two division bench judgments. One is Justice Pranab Kumar Chattopadhyay TV. The other is not an earlier judgment. I forget not the quorum. That's Dipankar Datta. So there are two judgments which say that this is merely an administrative boundary. Yes, if flush not connected to the original side, someone brings it to the original side, it has to be reconverted. But if cause of action substantially is in the original side, one respondent being here or there may not make a difference. In suit, it is very strict, but even if one defendant is outside, you can't maintain it.
All right. So it's maintainable. Should I record that?
I leave it to your lordship.
No. Do you want me to? You want to take that objection? Do you want me to deal with that objection?
Objection which is why are you taking that? My lord, kindly my lord records my lord that he doesn't have any objection. I'll tell Mr. Laha, these objections should never be taken.
All right. Yes.
I'm good.
Thank you, Mr. Banerjee. Yes.
Lordship, the petitioner is the owner of half of 162.
Yes.
Bipin Bihari Ganguly Street.
Yes.
And half of the property was gifted to his brother, who is no more, but his heirs are there on record.
Yes.
Now, my lord, the building is like this, my lord. There is a partition wall like that court and this court. Only there is a wall. There is otherwise no boundary between the two portions. Lordship, all through my client and the other co-owners of the building, they used to pay corporation tax, my lord, jointly in cash. They used to accumulate cash and pay. And the property was in the name of their predecessor in interest, Bipin Bihari, my lord, Kundu Chaudhuri. It is recorded in the name of their predecessor in interest, my lord. Now, my lord, the right to the property is not disputed here, my lord. They do not dispute that I don't own this property. Now, my lord, suddenly, my client, when he approached his brother's sons and daughters, respondent number 7, they said that they have already paid the tax, their portion. Being curious, my lord, my client approached the corporation office, and he surprisingly came to know that the property has been mutated in the name of a third person in whose name the tax has been collected. and the SSC number is given in his name. My lord, that third party, my lord, this respondent number 7 here, 6 here, my lord, he only has the agreement for sale in his name, not even a conveyance. And the property has been mutated in his name on the basis of agreement of sale. And the entire tax is collected from him, and the bill shows his name as the SSC.
Page 78.
Lordship kindly comes to page 78 once. 78, this is the document of the corporation, Lord, property tax bill. Care of Sri R. Kundu Chaudhuri. Lord, recorded owner, person liable to pay tax, Lord. In the middle, Lord, estate Binod Bihari Kundu Chaudhuri.
Yes.
The original owner who gifted the properties in the name of the two brothers, Lord. The next page also, Lord, kindly look at the next page. That is also in the name of Binod Bihari. This is the tax bill, Lord, paid up to
Page 79.
page 79.
Payment receipt.
This is the receipt of payment. The payment was made. Now, my lord, kindly comes to he passed away, my lord. There is a death certificate that is also not in dispute. Page 82. Page 82. No outstanding certificate which is obtained by my client, my lord. It says to the owner Riorgio Real Estate.
That's one number 6.
The respondent number 6. Person liable to pay tax. SSC number same, that of Binod Bihari. My lord, the property is apparently, my lord, that has been mutated in the name of a third person, my lord, who is claiming his right under an agreement for sale, not even a conveyance. My client, my lord, agreed, my lord, he gave a notice, my lord. Kindly come to page 111. This notice was given to the corporation authority with copy.
111.
Lordship, 111. My lord, the entire facts were stated, my lord, in the notice. And at page 115, after recording the facts, my lord, there is a prayer. In the circumstances, I hereby, on behalf of my client, call upon you to correct your records by incorporating necessary changes to the effect that the said entire premises and particularly the scheduled property is owned by the estate of Binod Bihari Kundu Chaudhuri. My client has been advised to take necessary steps for mutation. My client will take steps, my lord, step for mutation, my lord. Now, my lord, this is, my lord, insofar as the correction of record and restoring my name in respect of half of the property, my lord. Supplementary. Amar file আছে, আমার file. My lord, none of the private respondents who are the co-owners, my lord, they have raised any objection against my ownership of the property in respect of half of the building. There is no dispute. The corporation, without any notice, without any ascertaining the facts, what portion of the building was being sold or attempted to be sold, my lord, they have mutated entire property in the name of the intending buyer.
Yes, Mr.
Now, Lordship,
Yes.
now, my lord, I have also filed a supplementary affidavit, my lord. In that building, by leave of the court, my lord, in that building, my lord, now demolition and construction works are being conducted. Kindly see the supplementary affidavit. The photographs are annexed.
What is there in supplementary affidavit? What are you showing?
My lord, half of the portion of the building has been demolished. Kindly see.
Yes.
Page 14 of the supplementary affidavit, my lord, there are
Yes.
photographs.
Yes.
And my lord, the masonry work is going on, my lord. All pillars have been erected by putting in rods. It is a contiguous building, my lord. There is only a wall between the two buildings, partitioning rooms only. My lord, the entire structure is now in danger. And this is all under the nose of the corporation, my lord, under to their notice, and upon being permitted by them, as my client applicant.
But this is a separate cause of action as far as
Lordship,
this activity
but
is
the
concerned.
construction is there, taking advantage of that mutation of the entire property in the name. Now they are doing all these activities.
Yes,
So
Mr.
he is asking for deletion of the respondent number 6, name of the
Yes.
respondent 6 from the records of corporation,
Yes.
and to my lord restore as my learned friend has to in the name of the estate of Vinod Bihari Kundu
Chaudhary
shares.
application.
My lord, the application has been made to us by the respondent number 6 in a prescribed form, together with my lord the conveyance deed. The my lord says the agreement for sale or but
Agreement to sale can't be a conveyance deed.
no, it's a conveyance deed to us. I find my lord.
What is the conveyance deed?
Well, you can see
Sale deed?
this is the deed of contract.
Who is Shami Kundu? You are Shami Kundu.
Yes.
You are
Yes,
Shami
number
Kundu.
7. Yes.
You are saying that you have sold the property. You have
we have sold it.
included this.
Yes, madam. We have sold the property on 23rd August 2024. Madam. It's a demarcated property, madam. No bonds in that, madam. So we have exercised our right. Madam, we have sold the property in favor of respondent number 6. Now we have nothing to do with it.
My lord, this conveyance was not known to my client. This is, I believe, subsequently executed.
No.
This is of 2024.
My lord, I am for the
August
respondent number
2024.
8.
Yes.
23rd of August 2024.
Lordship,
They did not disclose.
it is not disclosed, my lord. The only document which is there, my lord, the agreement for sale, which is annexed to the petition.
That's right. But after that, they have sold the property.
Now, my lord, kindly see the agreement for sale, how they are describing the property. That is very important, my lord.
Schedule.
The schedule.
Now you challenge this sale deed if you are so aggrieved.
No, I'm not challenging because there is no dispute with regard to the property. The corporation, my lord, mutated the entire property in the name of his buyer.
No, on the basis of the conveyance deed, what about the property?
Conveyance deed is only to the extent of 3,000 square feet carpet area.
Yes.
The schedule of the property is there. It's only on the area more or less on the ground floor together with another office space. 3,000 on the first floor along with tin shed structure of 100 square feet on the second floor. How can you mutate the entire property? It's not the entire property, Mr. Ghosh. The schedule of the property is here along with the sale deed. How have they mutated the entire?
Well, I don't know whether the entire property has been. Let me see, my lord, the
Conveyance deed copyটা দেখি একবার।
See, there are two options. Either I remand it back, they consider your application which you have filed, your representation, or I ask them to file a reply. What do you want?
My lord, let them consider. The only thing is, my lord, that they should not allow the illegal activities in the contiguous part of the same building.
That is a different aspect altogether. You are not
because my
challenging
portion
that.
is getting damaged.
Sir, that is not under challenge over here. It is not part of your writ petition.
My lord, that is
supplementary affidavit. Supplementary
I have pleaded, my
affidavit.
lord, pleaded
Supplementary affidavit doesn't better your relief clause. Sorry, that's not something which you have asked for.
Well, till that time it was not constructed. There was
File a separate writ petition, sir. Amend your writ petition. Ask for everything.
My lord, দেখেছেন।
It is only confined to this. You want, I can remand it back. They will consider your representation. They'll decide it. Or if you want, they'll file their reply.
My lord, they can file reply. In the meantime, my lord, I'm praying for relief as paid for in the petition itself.
Relief in the writ
Lordship
petition,
kindly-
obviously, it's a final relief. Can't be given at this stage. They will file their reply.
Pay D of the writ application. my lord. Lordship will kindly come to the prayers.
Prayer page 22.
Page 22.
They have already done that, sir. This can't be given. They have already converted it. They'll file their reply, then eventually whatever will happen, will happen.
Lordship, as your lordship pleases. I'm
Mr.
leaving it
Ghosh,
entirely to you.
it's better if you consider his representation and decide this
If he
issue.
says with regard to the mutation, what has been done,
It's
he has
been,
say- if
Mr. Ghosh, let's be very clear.
if he has say,
Mr. Ghosh,
my lord,
you have the sale deed with you. Sale deed nowhere says that the entire property is.
no,
divided.
that's right. But
It has been
mentioned
wrong-
in the sale deed is mentioned, and he says also in a part of the property he's still there.
Absolutely.
Therefore,
There is
but
no dispute.
There is no dispute about that.
No
But
dispute.
if he has got to say anything with regard to that mutation, because I have proceeded on the basis of the document which has been submitted.
But you
to me.
can't do the mutation for the entire property.
No, of course not.
Today you
Of
have
course
done it
not,
for
my
the
lord.
entire
My lord,
property.
if it is the entire property, then it will be wrong.
Exactly.
But my lord, of course, my lord, because it must be
So that
confined
is
to
his
the.
grievance. That is his, he is not.
Therefore, my lord, whatever he has got to say, rightly my lord said, that may make a representation, get it heard by the authorities. concerned.
Representation is already
We
there.
have made, my lord, there is no reply to that.
So
Then
they'll
I'll-
consider your representation. They'll consider, I'll put it in a time-bound manner. They'll consider your representation. That's much better for you. At least you'll get something.
Lordship, before that, Lordship will kindly look at this particular schedule at page 96 once of the agreement for sale that I have annexed. Well,
I just saw the sale deed also.
How it is described in this agreement for sale.
That's all right. So that's what I'm saying.
You know,
You go
this is
back.
not the way how a schedule is to be described. Lordship kindly will see on the north by others land, on the south
Anyway,
30
now,
feet wide.
now this has traveled beyond that. It has converted into a conveyance deed. The schedule is described in the conveyance deed.
I don't know, my lord, the document is not with me.
Same schedule.
Same schedule.
Same schedule.
The
Oh, it's
conveyance,
not the schedule. It's not.
3,000 square feet.
3,000 square feet, yes.
So the same.
But the way it has been described, it's not there. So let them decide your representation. At least you'll get something.
and in the meantime, the mutation in the name of rear Joe, my lord, that should be stayed.
What state? It has already been done. What
Yeah.
state? It can only be
Entire
reversed.
property. Yes, reverse.
So that is only after your
Lordship.
representation is decided, sir. Can't be
Lordship.
done now.
Lordship.
Take down. The petitioner has preferred the present writ petition, challenging the insertion of the name of respondent number 6 as the owner of the property situated at 162 Bipin Bihari Ganguly Street. उससे पहले first line लिखना. Learned counsel for the respondent number 6 states that the respondent stays outside the jurisdiction of the original site, but does not wish to press this objection and does not wish to press this up. उसके बाद लिखना. उसके बाद Bipin Bihari Ganguly Street, Calcutta, and seeking restoration of the name of state of bracket inverted comma में करना, state of, वहीं से शुरू करना, word state से, state of Vinod Bihari Kundu Chaudhary ये यहाँ से ना ये वर्ड भी लिख सकते हो यहाँ पे विनोद बिहारी कुंडू चौधरी APPD share inverted comma page 78 I have marked it ठीक है थोड़ा spelling different है APPD share inverted comma close as the owner of the said property full stop. The case of the petitioner is that late Vinod Bihari Kundu Chaudhary was the absolute owner of the said premises, comma, and the municipal records also reflect reflect his name as such. Full stop. During his lifetime, he gifted the eastern portion of the property to the petitioner and the western portion to his other son, Rajat Ranjan Kundu Chaudhary. Full stop. Upon the demise of Rajat Ranjan Kundu Chaudhary, comma, the western portion devolved upon his two sons, Shamik Kundu Chaudhary and Sharajit Kundu Chaudhary. Full stop. After the death of Sharajit Kundu Chaudhary, comma, his share devolved upon his wife, Bhaswati Paul. Full stop. Accordingly, comma, the western side of the premises.
We are disputing that proposition.
That's all right. This is
number 8 is not the one.
this is only
What they have stated.
yes.
Petitioners.
After the death of Surjit Kund wife Bhaswati Pal, accordingly, the western side of the premises came to be co-owned by Shamik Kundu Chaudhary and Bhaswati Paul. Bracket में कर देना private respondent number 7 and 8. Full stop. 7 and 8. Full stop. Although the eastern and western side of the premises have been properly demarcated by a boundary wall, comma, no steps were taken to effect mutation of the property in the names of the petitioner and their legal heirs of late Rajat Ranjan Kundu Chaudhary. The property continued to stand in the name of state of Vinod Bihari Kundu Chaudhary. APPD shares, जो ऊपर लिखा हुआ है, and property taxes were paid by the parties in equal shares. Full stop. In the last week of April 2025, comma, when the petitioner approached respond number 7 regarding payment of property tax, comma, he was informed that respond number 7 had already paid his share. Full stop. On approaching the respondent municipality, comma, the petitioner discovered that not only were the property tax paid up to date, but also the entire state has been mutated in the name of respondent number 6. Full stop. Upon further query, comma, it came to light that the respondent number 7 had executed a registered agreement of sale dated 10/5/2024 in favor of respondent number 6, representing himself as the sole owner of the western side of the property, comma, to the exclusion of respondent number 8. Learned counsel for the petitioner submits that by virtue of the registered gift deed dated 6/4/1962, the petitioner is the owner of the eastern side of the property. Full stop. Accordingly, comma, respondent number 1 to 5 ought not to have mutated the property, the entire property in favor of respondent number 6. Even as per the agreement for sale dated 10/5/24, respondent number 6 could only claim right on the western side of the premises. Full stop. The petitioner, by legal notice dated 26/5/2024, called upon respondent number 1 to 5 to delete the name of respondent number 6 and reinstate the name of same, inverted comma, estate of Vinod Bihari Kundu Chaudhary, APPD shares in the municipal records. Learned counsel for the respondent municipality, Mr. Ghosh, states that the said mutation has been done based on the sale deed executed on 23rd of August 2024. Full stop. This a copy of the sale deed. Mr. Ghosh, give me a copy of the sale. A copy of the sale deed is kept on record of this court. Full stop. Mere perusal of the copy of the sale deed itself reflects that from the schedule of the property mentioned in the sale deed that it is not for the entire property that the sale deed has been executed, and that the respondent number 6 has only purchased the share of Mr. Somek Kundu Chaudhary, respondent number 7.
My lord, I have one objection. Respondent number 8 is
Take all
wife.
your objections.
My lord,
before
respondent number
the-
8 is widow of Saurajit Kundu Chaudhary.
Whatever it is, madam, take all your objection. I'm not deciding title dispute here. Full stop. क्या लिखवाया?
But that property, that portion is in between Bhashwati.
Oh, madam, you challenge the sale deed if you have to challenge it. Respondent number 7. All right. Learned counsel for the respondent number 8. Your 8. Respondent number 8 states that even the sale deed which has been executed has been wrongly executed, since she also has rights on the western side of the property.
Yes.
Full stop. Be that it may, it is evident that the
My lord, this is
What
The matter will go before the authority. That's
I'm not saying anything. This is just her submission. Be that it may, this court is only seized of the matter as far as mutation of the property in favor of respondent number 6 is concerned. From the sale deed itself, it is evident that the entire property has not devolved on respondent number 6. At this stage, learned counsel for the respondent corporation, Mr. Ghosh, states that they are ready and willing to consider the grievances raised by the petitioner in the aforesaid legal notice dated 26/5/2024. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the above, the present petition is disposed of with a direction to the respondent number.
Yes, as a collector, na? As a collector case. Now let me see.
Assessor and collector.
Your Lordship, better your Lordship may be pleased to direct one of the chief manager revenue to consider the matter. Because once the matter was decided at the end of the assessment collection department, but he might be a higher officer, he might consider the in total, or your Lordship,
Respondent number 1 to 5.
Assess the collector as your Lordship pleases.
1 to 5. I'll just mention 1 to 5. Respondent number 1 to 5 to consider and decide the grievances raised by the petitioner in the legal notice dated 26/5/2024 after 2024, strictly in accordance with law, after affording an opportunity of hearing to the petitioner and the private respondents herein within a period of
after the vacation, also give some time, my lord, after the vacation.
within a period of 12 weeks. Within a period of 12 weeks and within a period of 12 weeks by way of a speaking order and to pass a reasoned and speaking order thereafter. Needless to state, the aggrieved parties shall be at liberty to challenge the same in accordance with law. With the above direction, the present writ petition stands disposed of.
Your lordship says, my lord, any of the competent officer amongst the 1 to 5.
25.
Any of the
Otherwise, my lord,
any of the competent officer
amongst the 1 to 5.
among the respondent number 1 to 5.
Well, demand notice is of 25.
Sorry?
25. The demand notice date.
Yes.
It has gone as 24.
2025.
It has gone as 24.
Oh, sorry, 2025. Demand notice is not 24, 26/5/2025.
Yes.
25.
25/6.
25/6/2025.
Second affidavit of
Well,
25/6/2025. Demand that legal notice is 25/6/2025.
well, may I file
By
the
respondent number
affidavit?
1
sir?
to 5 shall be decided by any of the competent officer.
May I file affidavit of service, my lord, which may be
Affidavit of
kept on
service is
My
taken
lord,
on.
kindly give me leave to file my wakalatnama.
record.
Kalatama, you should have proceeding with regard to the grievances raised in the supplementary affidavit.
Will
Affidavit of service is taken on record.
Will it be my lord's pleasure to give me liberty to raise my grievance, my lord, insofar as unauthorized construction is
That's a
concerned?
separate cause of action.
But that is as a consequence of their.
That's all right, but that's a separate cause of action.
May that be recorded, my lord. I will.
Learned counsel for the petitioner is at liberty to file any proceedings as far as the unauthorized construction at the said site is being carried out in accordance with law.
I'm grateful.
Kindly record alleged.
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 I was just going to add as far as the alleged unauthorized construction.
Convinced to be kept.
I'm
in the
keeping
record.
it. I'm
Yes.
keeping it. Yes.
My lord, I'm the petitioner, my lord. I'm led by Mr. Jishnu Chaudhary, my lord. He's trying to join shortly through virtual mode. My lord, may I proceed?
Respondent, Mr. Chaudhary's client has suppressed certain material.
My lord, may I proceed with the matter, my lord? Then he can make his submissions.
If Mr. Chaudhary can point out that there's a suppression of the fact that in an
He
earlier
can
round.
place it on affidavit, whatever
why I'm
suppression
saying
is there.
suppression as
It is not necessary.
Why
He can only argue if he's challenging the maintainability of my application.
I'm saying that
Look, suppression is not a ground to challenge my application before I'm allowed to speak.
I am submitting that I may be permitted. No, my lord, suppression. When it goes
But then
Later on.
it is not a jurisdiction point. He can't take it. It's not a maintainability ground.
You're a senior advocate.
Yes, I know. I can never stop even otherwise. Not
No, you
being
should
a-
encourage, not stop.
I can't. I don't have the courage to stop Miss Chatterjee. The only thing is, Miss Chatterjee's
Totally.
client. Miss Chatterjee's client. No, I have the courage. Miss Chatterjee's client has suppressed certain material facts, including a report filed in court
May
to which he has not accepted.
Application.
Yes.
Yes, my lord. My lord, very short point in this matter. This is not only, my lord, a deviation from a reconstruction sanction plan, but also, my lord, a flagrant violation of the court's order. Two issues are there, my lord, and my lord, I am pressing for an interim protection on the basis of the conduct of the parties, my lord. My lord, I'll take your lordship, my lord. The matter started first, my lord, in April 2024. My lord, when I have discovered, my lord, I have some photographs which I've annexed to my petition, but for your lordship's convenience, my lord, I'm handing over colored photographs. My lord, I am the adjoining property, And my lord, there was the respondents, private respondents 11 to 12, my lord, they are my immediate neighbors. What they have done is, my lord, they had obtained a reconstruction plan from the KMC. And on the basis of reconstruction plan, they were carrying out some repair works. But what they did was, my lord, they went ahead and constructed portions which was not within the reconstruction plan, which is, my lord, is a courtyard area. And through that courtyard area, my lord, if lordship takes up the photographs, they have raised 3 columns. Upon these columns, their intention is, my lord, to completely cover the courtyard area. And also, my lord, they have constructed additional floors. As a result whereof, my lord, the adjoining property is now entirely affixed to my walls, even my neighbor's wall. So, my lord, this issue had happened last year in April 24. And if lordship takes up, my lord, page 36 of my application, there is a KMC record. Lordship kindly takes up page 36. It all starts from there. My lord, it's a KMC record. My lord, the property is situated at 1 Beedon Street. And my lord, at page 36, my lord, lordship will see serial number 7. Beedon Street, address 1, Beedon Street. Lordship kindly sees the observation, which is a part of the KMC record. Person responsible have a reconstruction sanction plan. No problem with that. But PR demolished some internal and outer wall and covered some courtyard portion and made 3 extra columns. Now what happened, lordship, pursuant to this report, I have made RTI applications. In the RTI application, this report has been confirmed that yes, there is a reconstruction plan, but I have gone ahead and they have gone ahead and constructed 3 columns there. Interestingly, my lord, after this, I filed a writ petition. Interestingly, they have come before this honorable court and they have themselves submitted that we have demolished it. And that order, my lord, is at page 39.
Page 39.
Yes, my lord. Kindly takes up page 39. None appears on behalf of the petitioner. This was my petition, but nevertheless, my lord, let the report filed by the special officer be kept with the records. The report of the special officer suggests that the respondent numbers 10 and 11 have undertaken construction as per sanction plan. Learned advocate appearing for corporation submits that respondent 10 and 11 have already demolished the unauthorized portion. They had admitted that there was an unauthorized construction which they have demolished. In view of the aforesaid, my lord, the writ petition was disposed of. My lord, I was under the impression my problem has been solved. What they have done is, my lord, they have repeated the entire thing all over again. They have started construction on over the demolished portions. They have created 3 new columns now, and lordship will take up my photographs. The construction is carrying on at an amazing pace. The workers are working at night as well. Rapid pace. Now the entire building has been made over above my building. There is an entire floor that has been created, which is not within the reconstruction plan. My lord, I have looked into, my lord, the building rules, my lord. It is a fact that you can construct portions which may not need a plan. But here they have covered an entire courtyard. They have repeated the entire exercise, which they had admittedly demolished and made those submissions on the basis of which my previous writ petition was disposed of. Now, my lord, when I have written letters to the KMC, there is no response. It is a part of their records. They are fully aware of this construction. There is nothing on record to show what reconstruction plan they have and how they are able to carry out these constructions. I am praying for, my lord, an interim protection. My lord, the vacations are starting in 2 days. Let them come back with their affidavits. Let Mr. Banerjee take whatever points he wants to take. But if this construction does not stop now, my lord, lordship will see the dates on my photographs. Every day the construction is being carried out at an unimaginable pace. They want to sell it off now. They want to encumber the property, create third-party rights in it. I will be left with no protection, especially in view of the fact that there was an order by this honorable court on the basis of their submission that they had demolished it. But if this is not a fit case for interim protection, what will I do, my lord? At least let them come back with their affidavits. If lordship decides, then we will see what can be done. I'm not praying for demolition right now, but the construction has to stop. That is my final order, my lord. But right now it has to stop. Even as on 23rd September, they have done it, which was 2 days ago. They are working overnight.
Madam, anything which is illegal will go. So
Yes.
let them construct it.
Well, they are going to create third-party rights. That is the reason they are doing this. It's a developer.
But
They are their
even if it
intention.
is third party right, it will be demolished.
I will be left with.
Doesn't allow You know, you must be reading all the latest judgments of the Supreme Court. What does it say? Demolition is demolition. Any illegal unauthorized construction will be demolished.
I agree, my lord, there will be demolition. But my lord, the whole purpose of an interim order, my lord, is to prevent that there is.
You should be happy. More bricks are added, more money is spent.
My lord, I am not.
Suffer more financially.
My lord, that is not my interest, lordship. My lord, let the construction stop for now, because my lord, they are going to create third-party rights, and this litigation is only going to get more complicated.
Really help any demolition or any construction or any illegal activity is not really supported by third-party rights. But yes, Mr. Das, what is happening?
My lord, my lord, only I am referring page 39. The whole
So what is the status? What is your
my instruction is this, my lord. Up till page 39, the entire story written here is actually that is created, because 39, if your lordship sees, this is the case which was started at that point of time by that writ petition. Now, my lord, the petitioner is creating something which is not there.
Not there. I'll record your affidavit.
Not there because
who is instructing you?
My lord, this is the petition which should not be maintained before your lordship. This should be actually, because my lord, if your lordship, may I read for your lordship?
Yes.
None appears on behalf of the petitioner at the time of call.
Yes.
Two times, my lord. So, my lord, when the special officer actually submitted the report, by that report is not annexed herein.
Yes.
From that report, I can show before your lordship. Right now, I have that report. I have not actually possessed that report. That the same case has been made out.
Mr. Das, you please tell me there's a specific averment being made by her that whatever has been the demolished portion has been reconstructed. Is that correct?
My lord, that is that.
Is that correct?
My lord, that reconstruction part, which is actually submitted before.
Take instruction, come back. Come back after lunch. Take instruction, find out if the demolished portion has been reconstructed or not.
May I make a few submissions?
Yes, Mr.
Just two things. Firstly, my lord, initially when the writ petition was moved, there was an earlier writ petition moved, my lord, about a year ago. Initially, when the writ petition was moved, there was an allegation that there was certain deviations from the construction. This was according to construction going on according to a sanctioned building plan. It's not any vertical addition which one is talking of. There were certain deviations in terms of spillage into space. That was the allegation. This honorable court, my lord, was pleased to send a special officer, and the special officer, my lord, filed a report before this honorable court saying that whatever there was additional spillage has now been undone. It has now come within the kernel of the building. This report was tabled or filed, my lord, before the honorable single judge taking up the matter in that writ petition. Despite this report being filed, the petitioner did not challenge this report. The petitioner then accepted, my lord, the report, and the order passed on the basis of the report. They allowed, my lord, the construction to continue thereafter because it was being done in terms of the plan. Now, just before the pujas, my lord, the petitioner has approached this honorable court with the ostensible purpose of trying to stop construction or getting an injunction so that he can enrich himself by abusing the process. Whatever constructions were being made at that point of time are still being made. They are being made in terms of the reconstruction plan. And whatever there were excesses in terms of spillage into my courtyard, not anyone else's courtyard, spillage into the internal courtyard, that has been removed. The entire thing is going on under the surveillance of officers. These are North Calcutta old buildings. Therefore, here you will not have a front open space, back open space available. The entire kernel is reconstructed in order to make it wind and watertight. That's a reconstruction plan. This is not a fresh sanction that one has to leave spaces. My learned friend says that he is the son of the owner in one of the writs. Here he says he is the co-owner, hasn't put any document on record to show how he's affected, even to show that he is the owner. Every 1.5 years onwards, my lord, he comes up with the same allegation. The allegation previously was that there was spillage, not into the portion of the courtyard within my premises, there was a spillage. He couldn't have suffered any actionable nuisance because of that. Construction was underway, so there's scope under Rule 26 for that plan to be during the pendentility, my lord, to be amended, changed to so as to bring, my lord, so as to factor in the spillage. This happens in every construction. Whenever there are columns put up, certain columns will, because of the engineering purposes, just deviate from the original site. You put in another revision plan and they allow it. That's how it goes during the construction. There is absolutely no allegation that there has been any spillage into his premises or the fact that his premises is under any kind of jeopardy.
But I have.
He's not filed, please, just a second, madam. He was at liberty to file a suit in the event he found that there was actionable nuisance. From 2024 June onwards till today, despite allegedly suffering, which he is saying in the second writ petition, he has not filed a suit to challenge the construction or the plan. If, my lord, if there's a question of damage or actionable nuisance, the place for him to approach will not be the corporation, it will be the civil court. He has not gone to the civil court. Today, at the fag end of the vacation, the reason why he has got this writ petition, my lord, mentioned and brought up in the list is because he wants to arm twist me to take money. He knows that the construction is at the fag end. This is the time when the developer will be most anxious to see that everything is completed. This is the time when he is striking. Lord, he was sitting on the fences up to this point of time. One suit, one injunction would have done the trick. If he says, my lord, today he says that in the building, portions of his building are being affected by my construction. If that is his case from the year 2023, may I ask myself, my lord, the question as to what he is doing, my lord, in September 2025 without having filed a suit? And he has not challenged that order of the special officer. The report is a detailed one. Special officer was one of the officers of court sent there in the presence of the representatives of the parties. There was a signature. And the signature was that whatever little spillage, this doesn't amount to vertical construction, spillage. In my part, there is a column which comes in. Instead of coming in here, it's coming here. That was the spillage complained of. We were so conscientious. Unlike the quintessential developer who's supposed to be a villain of the piece, we removed that part and we brought it in again in the kernel. Now, if today, my lord, any construction is examined at the time of completion, my lord will easily find 10% deviation in terms of spillages. All of them are then put in the form of a completion plan. Corporation comes and inspects. If there are small spillages, they are allowed to remain. No construction, and my lord can take my word on it, lord, kindly record my submission. No construction undergoing anywhere in the world is in terms of a sanction. There is bound to be at least 10% deviation. Now, my lord, the neighbor, the friendly neighbor who resurfaces once every 1.5 years just before a vacation to get an interim order surely cannot steal the march. Lord, kindly, my lord, if any report is called for, my lord, let the corporation file a report again. But the entire attempt today is to get an injunction.
There's no question of injunction.
There's no question. Let the corporation come and satisfy. They have not challenged this report. This report they ought to have annexed. Now, my lord, since Ms. Chatterjee told me that I shouldn't be intervening first, let me intervene in turn. This report is a vital piece of evidence. This is a report which shows that the expert's evidence has not been contradicted in the earlier round of the writ petition. That gave rise to Justice Chanda's final order, which my lord has seen. This report has not been spoken of in the writ petition at all. This inspection was ordered at the instance of Ms. Chatterjee's client. An officer of court was appointed who went and held up inspection, returned a report with the signature of the client on the report. That has not been contradicted at that point of time. Thereafter, this proceeding was kind of abandoned and Ms. Chatterjee's client went away. Today, my lord, in September 2025, before the pujas, he wants a bonus. That's the question I'm asking myself. Writ courts are not meant for the purpose of, my lord, pre-puja bonuses. There are other means, my lord, to get them.
Yes.
And every developer is not a villain.
All right.
Well, firstly, yes.
Why didn't you challenge this?
Well, I do not.
I'll dismiss this.
I don't have a copy of this special officer's report, my lord.
Yeah.
Let him at least provide a copy to me.
It's her writ. It's been served.
The special officer is appointed. What are you, Miss Chatterjee?
It's been served.
Lord, my instructing advocate does not have a copy.
Doesn't have. That's her problem.
Well, since my learned senior friend has it, my lord, I'm requesting for a copy. And my lord, let me go through it and let me come back at 2 p.m. lordship. I'll be making fair submissions in that regard. My lord, they have not even produced the reconstruction plan. My lord, all these allegations that he has made right now, they are all personal allegations. I'm trying to enrich myself and everything. My lord, let may I be given an opportunity to see the special officer's report?
Not going on the special officer report.
My lord, then, my lord, in that case, there is an order of the court where they have themselves come and admitted that they've demolished
on
it.
the basis of a report in which that
Well, this report is not with me. I am not being given an opportunity to deal with it. And there is an order of this Honorable Court, my lord, where they have agreed. Well, let me come back at 2 p.m. And my lord, I have filed this writ petition in August. This is an absolutely false allegation that I am trying to obtain an order 2 days before the.
They'll file their report.
Lord, where?
Take. The petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent authority in not taking any steps to stop the illegal and unauthorized construction being carried out at premises number 1, right?
Yes, my lord, 1
Vedant,
Bedan Street.
Vedant Street, Calcutta. Vedant Street, Calcutta. Full stop. This is the second round of litigation. Full stop. Earlier, the petitioner had filed WPO number
563 of
563 of 2024, alleging unauthorized construction at the aforesaid premises. Full stop. While order dated 5th November 2024, the petition was disposed of as the respondent corporation submitted that the private respondent had demolished the offending portion. Full stop. However, the petitioner, who is a neighbor of the said premises, has now noticed that the private respondent has again started reconstructing the offending structure and are raising illegal and unauthorized construction. Full stop. Aggrieved thereby, the petitioner had submitted a representation dated 26/6/2025. Full stop. No response has been solicited by the, no response has been given by the respondent corporation. Full stop. Learned counsel for the respondent corporation seeks and is granted 2 weeks after vacation to file his report by way of an affidavit. Reply to the same, if any, within 1 week thereafter. Learned counsel for the private respondent seeks and is granted 2 weeks time to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after.
My lord, I have one small prayer, my lord. In the meanwhile, my lord, let them not at least encumber or create any third-party right over the property.
Nothing.
My lord, let the construction is anyway
Construction
continuing,
has
lordship.
nothing to do with third-party right, madam. Nothing to do with third-party right.
My lord, in the event, my lord, they do, my lord, then I reserve my rights to come and, my lord.
Go to the civil court.
Civil court, get an injunction against me.
My lord, it is against the respondent authorities, my lord. The KMC has not taken steps.
Unauthorized construction has got nothing to do with third-party rights. Unauthorized construction remains unauthorized. Even if it is third party, fourth party, whatever rights are created. It doesn't matter.
I do not, after coming back, you will also take the matter, I do not see and dispose of. Well, I've taken the instruction with regard to item number 3.
Yes.
That no valuation has been fixed, decided.
Yes.
My client
That-
comes
that
right now, my lord, from the corporation. They say that the valuation has been done. It has been uploaded on the assessment book, and they will undo it in the event our challenge succeeds. So it's complete confusion. Only one prayer. I know. I'm not. Never can I even imagine of, my lord, questioning the instructions being, my lord, submitted by Mr. Ghosh. He's the most responsible person. my lord,
As
that
a
I know.
collector, I
But
personally talked to him. He
That's
said,
the
"My lord,
whole
nothing has
problem.
been yet."
There appears to be, my lord, there appears to be some infighting in the department for all they know. But only one thing I'm praying, I don't want any interim order. Please do not also make any orders, enabling orders in my favor. Please, my lord, direct them to file a report on the day of
No,
reopening. to
let
your
him
lordships.
file the objections, my lord, that will be heard.
My
I'm
objections
told
are there.
specifically
I
told.
don't know where I stand. Please, Lord. I don't know where I stand. Today, if there is an assessment made in respect of
He is
three,
making a
This is
statement.
my instruction,
I'll
my lord,
record
through, my lord, from the SSA collector. You see, record
I have
that.
recorded.
If he raises an objection, that will be
I
put
can
to hearing.
I can understand. Lord, ordinarily that would have done. In fact, in all cases, that should do. A recording of court is sacrosanct. The instruction given to him regarding the 5 premises numbers, unfortunately, my lord, as it appears from what we've come to know from there, may not always be the correct instruction coming forward.
But I'm saying, my lord,
this with
it is, my lord,
responsibility.
I have talked, my lord, with the SSA
I know
collector
it's neither here nor there.
That is specific instruction, you should record it.
I'll record his instruction. They will consider your objections.
My lord,
Then
then
that will
If
be
there is an objection, that will put for hearing.
Then, Lord, kindly record.
Even if today they have done something, they'll undo it.
No difficult. Then Lord, kindly records that these assessments are alive, the proposals are alive, and then, Lord, on the basis of that, permits me, Lord, some time to put in my comprehensive objection. Let them hear out thereafter.
Take down. The petitioner in the present writ petition is challenging the notices issued under section 182, right?
184
180
and 185.
180,
184 and 185.
184 and 185 of the KMC Act.
But I'm challenging their maintainability, my lord. I say that I'm challenging the maintainability of the proposals itself. So,
maintainability, if you're challenging, then we will, in terms of section 232, with what?
Yes.
Then that can be decided.
I'll decide it along with that. I'll come up with a supplementary affidavit. My lord is deciding that.
Mr. Banerjee, if you want your objections to be decided by the corporation, as far as this is concerned, 184, 185, 186, you can file your objections.
And 187 hearing officer, 188 order, 189 appeal.
Right.
But in cases where they are invoking 232B and they are making retrospective assessments for 15 years, 20 years at a time, though that batch of matters is pending before your lordships. My lords will be hearing that, Lord, that is partly heard by your lordships. Kindly, therefore,
what do you want, Mr.?
My lord, kindly do not make any order today. I'll make a prayer that this matter be listed there after the opening. So that, Lord, I know what my fate is. Otherwise, when I go there, there are 3 assessors who are saying 3 different things. Mr. Ghosh will set that at rest, but in the department, my strife will continue. And, Lord, I'm a regular payer of tax. Lord, on my prayer, Lord, therefore, Lord, let the matter return after the vacation, so that I can make that prayer before Lord.
Then I will not record anything. I'll just simply adjourn the matter.
Adjourn it. Yes.
At the request of the parties, let this matter be listed after vacation.
I'm obliged, Lord. I'm deeply obliged.
I'll give a date, Mr. Banerjee. You want a date?
What about the 2 matters I'm told, because he's ultimately questioning about the 232B, my lord, the challenge regarding that.
That is coming up then.
Right. Since, my lord, the 2 others are cases are pending, I am told, my lord, the lordship is hearing already. Heard already. Then it could be put, my lord, along with that.
Yes, Mr. Ghosh will also get
When
a
is
chance.
the date for that?
That was.
That could be put because there are 2,
We'll give you lordships the date. We'll give you lordships the date.
It may not be, my lord, hard when a piecemeal.
Then you file an affidavit.
Yes, file an affidavit.
But this is the legal question, my lord, because affidavit does not require, because he is raising an illegal question. Because virus he is challenging. He's challenging the virus. If the virus, my lord, is affair is one thing. If the virus is not affair, my lord,
So
then
he's challenging both. You have to file an affidavit if he's challenging the virus. You have to put your stand.
I don't know, my lord, whether in other cases, my lord, affidavits have been filed or not.
Must
Mr. Joydeep Kaur is appearing. He's filed.
He has filed it. So then I'll give a direction.
In relation, let this, my lord, come along with that, my lord, matter.
Take down the petitioner in the petitioner in the present petition is challenging section, the virus of section You're challenging the virus of section.
No. I haven't. Here I haven't.
All right.
Here I haven't.
Is challenging section.
Yes, I find it.
I've done. I'm so sorry. I got.
Challenging the virus of
232B and 182.
is challenging the virus of section 232B and section 182.
182 the mega 2.
Proviso of the KMC Act 1980. Full stop. The petitioner is also challenging the memorandum dated 17th May 2025, along with the reassessment valuation proposing to give effect to the same from a anterior period from 2011 onwards. Full stop. Learned counsel for the respondent municipality seeks and is granted 4 weeks time to file affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List on. When are those uttered? 6th November. 6th November are the other matters. This won't come on 6th November. Give it after that. We'll see.
Let them come.
Let it be put on 6, my lord. I along with that.
On 6th, Mr. Ghosh will file his affidavit by.
কিছু হবে না ওইটা হয়ে গেলে কোনো এবিডি লাগবে না দেখা যাবে
Let him file his affidavit on
দেখা যাবে কোন সেটা
come on 6. I will never, my lord, make a prayer that your lordship forecloses the right. If he asks for more time, lordship will give him them. For the time being, let it appear on the 6th.
No, then if 4 weeks and 2 weeks, it will make it beyond 6.
Much beyond.
Much beyond 6.
Opening date, the opening date, my lord, and 3 days thereafter. The opening date, he gets more than 4 weeks. The opening date, 3 days.
Nobody would be able to file it. Let it come after that. Whatever will be the outcome, we'll see that.
The only one case is decided, then automatically
same
you follow the other cases.
Exactly. The
There
issue
is
will
no
be followed.
necessity of, my lord,
Multiplicity does not require.
Then Mr. My lord would be benefited from. My lord would be benefited from Mr. Ghosh's counsel. my lord.
He's always there.
The council is already, my lord, addressing to your lordship, my lord,
He's always there.
Mr. Kar is there. Mr. Mukherjee is there. Now Mr. Ghosh will come. The proverbial Trishul, my lord.
Dangerous. We'll have it in, give it in November, then on the 20th of November. 20th.
I'm appealing for the petition number.
Yes.
Praying for the acquisition of time for file my exception man. It was granted, but the petitioner is.
Why you have not filed it?
My lord,
Unauthorized construction, we
yes,
can
on the last
put it
day,
off.
I have missed the list, my lord, but the petitioner is out of station to his native place, my lord, due to the illness of his mother, my lord. That is the only.
Your lordship, my lord, on the last occasion, my lord, decided that the matter to be, my lord, dismissed because, my lord, your lordship said the petitioner is not coming.
Correct.
The only, my lord, the one of the respondents, my lord, he want to be added as a party. He is concerned about one particular, my lord, premises. There I have, my lord, put in, my lord, in affidavit, my lord, stating that the one portion of the building is unauthorized, other portion is sanctioned one. We have been taking in terms of the order of this court, but for demolition of that part. I don't know, my lord, what more interest, my lord, the added party, he wants to be added. He has not even been added as a party.
Yes, my lord, Kali comes to my lord's order.
You are petitioner in this.
Yes, my lord.
He has not even been added.
No,
I'm
he's
the
the petitioner.
Petitioner.
Yes. He's the petitioner.
So long, my lord, he was for the first time after a long period of time, my lord, he is coming.
My lord, on a education I have been.
Learned counsel for the petitioners seeks and is granted 2 weeks time to file his exception to the report filed by the respondent corporation. List after. 13th November. 13th November. 13th November. Yeah.
After a long time, the petition has come.
Yes.
You are also inquiring. I repeatedly submitted the petition. Is
So why you were not appearing?
On the last occasion, I have not appeared on this matter. Yes, my lord.
You were not appearing on many occasions.
No, my lord. Only on the last occasion, I have not appeared.
সার্টিফিকেট কপি চাইছি
হ্যাঁ তা দিয়েছি
এবার একটা দিয়েছি আরো দুটো চেয়েছি তারপরে পয়সা দিলে কি ফেরত যেতে হবে যোগাযোগ করবে এখানে
Yes, I am for the petitioner in this matter.
Yes.
One small point is involved.
I have applied for certified copy for 3 sets of the demolition order. They have only supplied 1 copy, and remaining 2 copies they are not supplying. On the ground the additional fees has to be paid. Already I have paid the amount they have demanded. Considering that I applied for 3 copies.
Do it, Mr. Ghosh.
No, I want whether any rule is there or law is there, that they should have communicated to me.
Copy, anybody will give it to him.
Yes, or if he paid all the for
paid
3
the money.
sets, 3 sets he will paid, my lord. Of course, well, it will be paid. It will be handed over to him.
I have already paid. Kindly see that I have already paid 1,000 rupees.
That is 1,000 for possibly, well, it is for 1 copy of the order.
When will you?
Where is the provision?
He has already paid the money for the 2 copies also. When will you give it to him?
3,000, 1,000 কত করে ফি? 3টে ফি শেষ, এখন 1.5 হয়েছে বোধহয়, 1,500 টাকা per copy. Well, I do not know the exact amount of fees for the certified copy. He has paid 1,000 rupees. If he wants 3 sets,
all right, whatever, I'll record your submission that he will pay the appropriate
the additional fees required, that is on payment, it will be handed over.
Let me just show now the provision of the statute.
Take down. The petitioner has preferred
No, they are not supplying.
petitioner has
No,
preferred
no,
the present writ petition seeking a direction upon the respondent number 2 for providing 2 additional set of certified copies of the orders dated 9/12/2022 and 18/9/2023 passed in demolition case being number 071/D/BR BR-V 2021 ward number 45 to the petitioner. Full stop. अगर यहाँ से चाहिए होगा page 7. Yeah. I marked it. It is the case of the petitioner that he wanted 2 additional sets of certified copies of the above mentioned order so that he can file it in civil suit PS 469 of 2020 and criminal case being C 24095 of 2012. Full stop. Earlier he had applied for 3 sets of the certified copy and paid 1,000 towards the charges. Full stop. However, he states he has only been provided 1 set, which he has filed in his BT appeal number 7 of 2024 before the Municipal Building Tribunal. He requested the respondent municipality to supply 2 more additional sets to be filed before 2 different forums. Full stop. However, the respondent they have refused or they have not given.
They refused, Miller.
However, the respondents have refused to give the same. Full stop. Being aggrieved, the petitioner has preferred the presented petition. Learned counsel for the respondent, municipality, Mr. Ghosh, submits that they are ready and willing to provide 2 additional sets of certified copies of these orders, subject to the petitioner depositing the requisite fees.
That is the challenge.
Within a period of, what is the challenge?
That demand is under challenge. Under which provision they are demanding money?
You want to pay or you don't want
I am agreed, but they want to show the provision.
Do you want or not?
I agree.
I'll ask them to file a reply 8 weeks, 6 weeks. Do you want copy or you don't want copy?
No, I want copy, but
yes, all right. Requisite. Obviously, anybody will take fees only if they are provided in the act. Will he take it in his pocket?
I have already
saying.
Well, that is not the point. If their provision is there, I am ready to pay.
Anybody, department will only charge if there's a provision, sir.
They are not positioned to show. That is the point. Even neither before the lordship
all
nor
right.
me.
Respondent to file affidavit in opposition 6 weeks, 2 weeks, 8 weeks, December. What is this? You are getting the certified copy.
That is not the point, my lord. That is the point of law.
Sir, do you see what the court has recorded? Only if requisite fees is permitted. Can anybody ask you for something which is not permitted in law?
On the basis of that, the matter can be disposed of. All right. All right.
What is wrong with you?
All right. All right. All right. All right.
senior lawyers like you.
Below kindly, so they are not cooperating. That is the point. So, number of.
We are here to make it.
All right, I will come out again if they are not cooperating. No issue. করে দিয়েছি রে, সবটাই তো করে দিয়েছি। সবই তো ট্যাপ নিয়ে নিচ্ছে। আপনি প্রত্যেকদিন ডেট, আমি ডেট নিচ্ছেন। প্রত্যেকদিন
In accordance with law. Full stop. In view thereof, comma, the present writ petition is disposed of by directing the respondent number 2 to provide 2 additional sets of certified copies of the above mentioned orders, subject to the petitioner making requisite payment towards any additional charge, if any, to be paid by the petitioner within how much time?
Well, as and when he goes and pays the amount, he wants to see that the payment is required, then immediately it will be given.
Within 2 weeks from the date the
2 weeks
petitioner
continuously holiday for
2 weeks after puja vacation. With the above direction, the present writ petition is disposed of.
In regard to item number 6, I miss to find the exceptions.
Item number 6.
Yes, my landlord I have already started.
Who are you appearing for?
I'm appearing on behalf of the added party.
Added party?
That matter was not added as yet. The petitioner for the
You should have been here on time, sir. Sorry. File it next time.
Next time.
I am for the respondent.
My item number 8, I am for the state, my lord.
I am for the respondent corporation, my lord.
Yes, madam.
My lord, I am praying for adjournment, my lord.
Why? What
But
happened?
And I am filing a report. Report was directed to be filed. If
That
your
was
lordship
not
directs me, I will file.
What is there? Unauthorized construction?
Unauthorized
Yes, my
construction.
lord.
That is their allegation. It is a school running for 40 years.
Why do you want a date?
My lord, the instructing advocate, Mr. Kaustubh Chandra Das, passed away, my lord. Therefore, I need to take instructions from the client, my lord.
Learned, you are the main counsel or the proxy counsel?
I'm the advocate on record, my lord.
Advocate. Learned counsel.
But your lordship can dispose of by directing the corporation to consider the representation also, subject to correction, my lord.
No, Mr. Somebody has
My-
died.
Yes, my lord.
Learned counsel for the petitioner seeks an adjournment on the ground that her instructing counsel has deceased. She prays for a short adjournment. Let this matter be listed after.
Gratefully.
But I'm appearing through virtual mode, my lord.
Yes, give your appearance, Mr. Devjit Mukherjee for state and Mr. Banerjee for corporation. List on November 28th November. 27th November.
Gratefully, your lordship.
Next day, 27th November.
My lord, I am for the petitioner, my lord. In view of your lordship's direction, my lord, in exchange affidavit, my lord, this is my affidavit in reply. My lord, this is the matter relates to, my lord, an unauthorized person not being a Thika tenant. My lord, who obtained, my lord, trade license, my lord, in respect of my property, my lord.
reply diyecho?
Huh? Reply, this is reply against a private respondent.
Oh, well, I am filing the opposition to Amar reply.
So these,
You are appearing for the petitioner?
yes, my lord.
Well, I am filing my opposition. He is, my lord, giving reply to the opposition of the private respondent.
আমাকে দেওয়া হয়েছে?
হ্যাঁ, দিয়েছে তো।
তৈরি হয়েছে? My lord, I think
You file your reply to that.
Certain development has, my lord, made, my lord, following the order of Justice Tirthankar Ghosh in a, my lord, writ petition, my lord, challenging the police inaction, directing the magistrate, directing the petitioner to go before the magistrate. On the basis of that, petitioner filed one application 156/3, my lord. And following that application and order, an FIR was lodged, my lord, against the private respondent, my lord. I relied on that FIR, my lord. My lord, it was found, my lord, as a ground of trespassing. The charge under my lord BNS of trespassing charge that was kindly consider one unauthorized, and last license was issued in my favor after hearing both sides.
Very good.
Kindly fix a short date, my lord, after just a
Affidavit in opposition filed by respondent number 1, 2, 3 is taken on record. Learned counsel for the petitioner seeks. How much time to file your reply to the affidavit of 6? 1 week after vacation to file his reply to the said affidavit in opposition of the respondent number 1, 2, and 3. Full stop. Learned counsel for the petitioner has filed his reply to the affidavit. Reply to the affidavit of opposition filed by respondent number 5. The same is taken on record. Full stop. Let this matter be listed. Same date de do.
Number 10, my lord, I am for the petitioner. Your lordship directed in the last occasion, my lord, to submit a report in the form of affidavit. Report has come, my lord, but not, my lord, by an affidavit. If your lordship, my lord, takes it as all right, my lord, otherwise, my lord,
No, affidavit.
put it by an affidavit.
By an affidavit.
My lord.
Learned counsel for the respondent corporation seeks and is granted 1 week after vacation to comply with the order dated to file his affidavit, to file his report by way of an affidavit. Exception to the same, if any, within 1 week thereafter, based on. Give a date. 27th.
Item number 11, Mr. Proneet Bak is appearing. I'm praying for a short passover. He's on his legs before the court number 37.
What is the matter? Are you aware?
It is a matter, my lord, regarding that certain, my lord, taxes was, my lord, claimed. He is complaining that he can't be, that cannot be, my lord, raised. My lord, I have got the instruction. The property was developed. There are several numbers of from the mother associate. There are several, my lord, numbers of child associates are there. That whatever the charges have been taken, my lord, that percentage is 4.98, 5% only. That is the amount, my lord, he has a claim. He says that I have come into the property, my lord, 2022. Why should I pay, my lord, from 2011-12? That is also, my lord, for the purpose of mutation. It says, my lord, if there are dues, because the original the owner was there, the property from since then, my lord, property was developed, and my lord, whatever the dues accrued, all the persons who have come into the occupy the units, different units, possibly 15, 16, 17, 18 units are there. That has been distributed at the time of Malad proportionately. That is also in the agreement. But I have got Malad details, Malad particulars I sought for from them, Malad. That has not come. Only Malad, I'm told that 4.98% of the, so far as this assessment is concerned, has been claimed. But if your lawsuit takes it after vacation, then I can give you Malad full particulars. How many units are there? How it has been distributed amongst the persons concerned? How his liability has been Malad calculated by the authorities.
You file your
affidavit, your lordship. That will also support us.
You are challenging the
Lordship, I am challenging the letter of intimation on me because I have purchased in 2022. The property has came into existence in 2020.
Take down. The petitioner in the present petition is challenging the letter of intimation
Lordship.
Dated 30th/8/2024 for the outstanding property tax qua premises number 19, Brojo Dulali Street, Calcutta. Full stop. The petitioner is also challenging the enhancement of the annual valuation of the premises in question from 23,330 to 85,840. Full stop. It is the case of the petitioner that he had purchased the premises in question by conveyance deed dated 8/8/2022. Full stop. Later, on 16/8/2024, the petitioner came to know from the online portal that the annual valuation of the property had been enhanced from 23,330 to 85,840 under the unit area assessment scheme. Full stop. The petitioner states that he had paid the property tax for the 4 quarters of 2020. Increase in property tax was due to retrospective assessment of the property in question. Full stop. He states that no notice was served upon him. Full stop. The respondent issued a letter of intimation dated 27/11/2024 in which the total outstanding property tax qua the premises was reflected at rupees 1,58 lakhs
479.
479.
So Lordship, it's 1,58,000.
1,58,000.
1,58,479.
It is the submission of the petitioner that the impugned order has been passed without affording an opportunity of hearing to him, as well as the apportionment has not been done.
And Your Lordship, that the property itself was not in existence at that point of time. It was a consolidated piece of land.
As well as he states that the property itself was not in existence
At the relevant point of time because it was a vacant
at
land.
the time when the demand has been raised.
For the period of which demand has been.
For the period for which the demand has been. The property was not in existence for the period for which the demand had been raised. Full stop. Learned counsel for the respondent municipality seeks and is granted 4 weeks time to file his affidavit in opposition. A reply to the same, if any, within 2 weeks thereafter. List on 27th November.
Grateful, Lordship.
I am challenging the revision of the annual valuation of the premises, but on the ground that one of the order has taken into consideration something which is not there on record.
What is it?
That the authorities order.
Why should we get into these things, Mr.
It can be done by the tribunal. If that is the point, a tribunal can consider.
Exactly. Why should I entertain this?
In fact, the last
Why
day
should
the
I
courtship
entertain?
made
But,
up your mind.
I'm going to dismiss it.
But my only
You
ground was.
either withdraw or I'll dismiss it. I am not interested.
Lordship will kindly give me one moment.
You have the liberty, go before.
Kindly, my lord, gives me liberty to approach the tribunal.
Learned counsel for the petitioner seeks to withdraw the presented petition with liberty to approach the appropriate forum in accordance with law. With the above liberty, the presented petition is disposed of.
But may I seek for one indulgence? But in the meantime, the limitation for preferring the appeal has.
File an application before that.
But I shall file that
I'll
application.
consider.
Well, Lordship will kindly direct me if in the event I file that application, I'll have to file that application.
To consider this,
Yes,
you
yes.
can always raise this point. I don't need to comment.
Told one of the.
That is like passing of an order on behalf of the tribunal.
But if that one observation could be made, then one of that will.
I don't want to prejudice them. Why should I?
My senior friend is not taking that. He's been gracious enough not to take that point. So that is why I was only beseeching this.
No, that is like I'm allowing the application. You file an application, they'll allow it.
How the application starts, I said that I think whatever falls from the quota.
That I taking a cue from that, if your lordship could make that observation.
How, Mr. Mukherjee, how can I make that observation? That is literally like
Since he was pursuing the remedy at the if any application
the
is
learned
made
con-
for
the-
confirmation, that would be considered favorable.
So grateful to my lord as well as my lord.
The petitioner, since the petitioner has been pursuing his remedies before a wrong forum, this fact shall be kept in the mind of the tribunal at the time of deciding his application for limitation.
So grateful. Grateful.
Application for condoning the limitation.
Grateful. Grateful.
The tenant is challenging my notice of demand. The notice of demand is at page 17.
Where is he? Today is not here. Maybe he has vacated.
I do not.
None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed after vacation. None for the petitioner. In the interest of justice, adverse orders are deferred. Listed on the 6th of November. मिस तो नहीं क्यों?
This is my application. This is in relation to taking over possession by the superintendent of Newmarket forcefully, in spite of orders passed by this honorable court and in spite of pendency of a suit.
Who's there?
Nana?
You're there. Yes. Tell me.
Lordship, if I may just indicate what had happened. One, Parvez Latif was the original lessee in respect of 3 shop rooms in Stuart Hogg Market. Lordship, after his death, a dispute arose between his widow and his father and other siblings. A civil suit was preferred.
So Parvez Latif.
Parvez Latif.
He was
the original lessee in respect of 3 shop rooms in Stuart Hogg Market.
Okay. Yes.
The shop rooms were N2069, N2068, and N2014. Lordship, after the death of Parvez Latif, a civil suit was filed before the City Civil Court at Calcutta. Lordship, before the 6th bench, claiming inheritance as per the Shariat law. Lordship, during the pendency of the suit, the shop rooms were transferred, 2 of the shop rooms were transferred in the name of the widow. And a lease was executed. And possession was sought to be taken over. Lordship, at such a time, we come before this Honorable High Court with a writ petition. And an order is passed in the writ petition. The order is at page 108. If your Lordship will kindly come to page 108. Your Lordship will find the petitioner submits that they were served with a notice directing them to vacate stall numbers N2069 and N2086 on the 2nd floor of SS Hogg Market, Calcutta 700. It is submitted that the notice was affixed at the premise on 23rd April 2024. It appears that one Parvez Latif was a lessee in respect of the aforesaid 2 shop rooms by way of a lease granted by the KMC. Parvez died on 11th July 2020. A dispute cropped up between the brothers and sisters of Parvez, petitioners on one side and his wife Parvez, respondent number 5 on the other side, regard to mutation of the aforesaid 2 shop rooms after the death of Parvez. The corporation, however, mutated the relevant assessment record in favor of respondent number 5. That's the widow. The petitioner filed a suit being titled suit number 717 of 2023 before the learned 6th bench City Civil Court at Calcutta, inter alia praying for cancellation of mutation in favor of the respondent number 5. This is the mutation in favor of the widow. An injunction application was also filed in connection with the suit, restraining the respondent number 5 from creating any third-party interest in respect of the aforesaid 2 shop rooms. Learned advocate appearing for the petitioner submits that the corporation, despite pendency of the injunction application, is trying to forcibly evict them from the aforesaid 2 shop rooms. It is the case of the petitioners that they are in possession of the said shop rooms and they are running tailoring business from the said 2 shop rooms. Respondent number 5, however, disputes such allegation. The corporation, on the other hand, has submitted before this court that it will not evict the petitioners from the shop rooms in question without taking recourse to due process of law. Lordship, this was a submission made on behalf of the corporation. In view of the stance of the corporation, I am not inclined to keep this writ petition pending. I grant liberty to the petitioners to question the propriety of the notice appearing in page 124 of the writ petition. That is in respect of the other 2 shop rooms where a notice was given asking me to vacate. And it was sent to the pending civil suit to seek appropriate reliefs in the suit. I also direct the learned judge in the trial court to dispose of the pending injunction as expeditiously as possible. In spite of this order, Your Lordship, forceful possession is taken of the 3rd shop room, which was not a part of this writ. Lordship, kindly drawing your attention to the suit itself. Your Lordship will find the plaint at page 37 and the schedule is at page 47. Kindly come to page 47 once. Your Lordship will find that there are 3 properties. Schedule A is shop room number N2069, which is the subject matter of the earlier writ. The second Schedule B is N2086, which is also subject matter of that writ. And the third shop group was N2014, which was not a part of the earlier writ because possession at that time had not been sought to be taken over by the KMC. Lordship, this suit was filed in 2022. I'm sorry, my lord, in 2023, 717 of 2023. Today, during the pendency of the suit, the KMC chooses to determine that the title will go to the widow and take forceful possession of the property. Your Lordship, I will be relying on just one judgment to show that the KMC is not entitled to determine the title and it can only be determined as per law. Lordship, it's a judgment.
The suit is still pending.
Yes, my lord. It is still pending. They have filed an application under Order 7, Rule 11, which is also pending. The hearing has been concluded of the Order 7, Rule 11, and it's at that stage. No order has been passed.
My lord, if I may, my lord.
If your lordship kindly takes the judgment, it's reported in 2008 SCC Online, Calcutta 298, also in 2008 Volume 2 CHN 905. I will not, it's a lengthy judgment, your lordship. I will not trouble your lordship with the entire. Kindly come to paragraph 51. Has your lordship got paragraph 51? Lordship, this was in respect of the Gadiahat New Market.
Yes.
Which is also controlled by the Kolkata Municipal Corporation. Kindly take paragraph 51. The court is of the view that unless the right of the respondent number 7, this was also a fight between the father-in-law and the widow, is established in accordance with law and before the appropriate forum, such a wish, desire of the respondent number 7, which was the widow, cannot be allowed to materialize unless the rights of the appellant are also taken into consideration. Since such consideration was already been refused to be given by the mayor, we therefore consider it appropriate to hold that the learned trial judge could not have termed the said refusal determined as a decision of the corporation. We are also of the view that since the right of the respondent have not yet been decided by a court of appropriate civil jurisdiction in accordance with law and on the basis of materials on record lying with the corporation, the learned trial judge fell in error when he virtually extinguished the right of the appellant by saying that his wife Krishna was lawfully entitled to request the corporation to mutate the records, incorporating her name as the permit holder of the stall. We'll kindly come to paragraph 53 thereafter. For the foregoing reasons, we are of the view that the order of the learned trial judge cannot be sustained. As a result, we set aside the impugned judgment and order dated 3/9/2007. As a result, we also set aside the letter communication dated issued by the respondent informing the Honorable Mayor have not considered quoted. This is the Mayor making a determination. The appeal is therefore allowed, but in view of our reasoning given above, we desist from remanding the matter back to the corporation. We therefore give liberty to the respondent number 7 to get her rights established before the civil court in accordance with law. We take notice of the fact that the title suit filed by the appellant, being TS number 305, was dismissed on 19/7/2006, as was also evident from the photocopy of the order produced from our perusal in the court, but we've also noticed that the said dismissal was a dismissal for default because the plaintiff appellant had not taken steps for service of copy of the plaint. Lordship,
So what had happened here is that probably on the order of the mayor, the trial court had granted the.
Yes. So over here, what it says is that the only court is the civil court. The rights of inheritance to a lease can only be granted by a civil court and not by way of a corporation determining it. Lordship, I have placed the plaint. The written statement has also been filed in the suit by the corporation. Your Lordship will now kindly take page 21, paragraph 34.
Yes.
This is post passing of that order, which I placed at page 108. Your Lordship will kindly take page 21. Your Lordship, in fact, we can start from page 20, paragraph 34. Has Your Lordship got it?
Page 20.
Paragraph 34. It's the last paragraph right at the bottom. Your petitioner states that on 25th February 2025 at around 7 p.m., the respondent number 12, Your Lordship will find the respondent number 12 here is one Shanaz Parveen, that's the wife, that's the widow, who's claiming right, accompanied by her brothers, being the respondents numbers 13, 14, and 15, and their associate respondents numbers 16, 17, and 20. Other people wrongfully and forcefully barged into shop room number N2014. This wasn't the subject matter of the earlier writ because we hadn't received any notice. In fact, till date, we have not received a notice.
All this is pending before the civil court.
During the pendency of this civil suit, KMC
comes. Then you should go before the civil suit. You should file an application before the civil court. Why have you come here in writ petition?
Lordship, because we are stuck because the order 7.
Same cause of action.
Yes.
Now, how is it writ maintainable?
I'll tell you, Lordship, why. As far as the suit is concerned, it's a determination of my right. As far as this writ is concerned, kindly see the conduct of KMC officers.
Get a stay from them. Get an injunction. Get an injunction from
Lordship, the injunction application is pending, cannot be heard because they keep on filing Order 7, Rule 11 applications until disposal. We cannot hear it. But your Lordship will kindly see what they do.
This is multiplicity of proceedings.
No. Lordship, I was only relying on the earlier order where KMC gives an undertaking that we will not dispossess you. And then they come back and do exactly that.
And go and file a contempt.
Lordship,
go and file a contempt before the same court.
Lordship will.
I am not interested.
Your Lordship will kindly just allow me one more.
Sure. We'll have it after lunch. We'll hear you after lunch.
Very well.
After lunch. Yes. After division bench, or we have a division bench. I don't know how much time will it take. Yes, but then if we hear that matter, then we can't have it today. Good for you, actually.
Lordship, we've been dispossessed.
So Ghosh seems to be lucky. You try your luck after vacation. All right. All matters after vacation.
All matters.
All matters. Because I don't know how much time the board will take.
Lordship, Lord, very happy.
Thank you. Thank you so much. Thank you. You too.
The wishes for all of us.
Thank you. Thank you so much. You have a wonderful